show. This show talks about everything in the law of personal injuries and relevant to you, the viewer. My name's Tony Carbone. I'm a lawyer with 30 years' experience. With me today, we've got Don Maffia, a partner in the law firm in car accidents. Good evening, Don.
Good evening, Tony. Good evening, viewers.
And Anna Hall, an associate in the law firm dealing with car accidents. Good evening, Anna.
Good evening, Tony. Hi, viewers. Lovely to be here.
Tonight, viewers, we're going to be doing an update on car accidents, so please stay tuned. There's some very interesting cases there.
Now, Tony, I noticed you're wearing a little band today. You want to explain to viewers what you're wearing there?
Yeah, if the viewers recall, last week I had all these badges putting holes in my suit, but this week what I've got is this little band. It's a Bully Zero band. It says you ring 1-800-0-BULLY. Now, this is directed to the people that have been bullied. If you've been bullied, ring up the centre and ask them how to sort out the problems. So it's not only about raising money to educate, but it's also about helping the people that have been bullied, Anna.
Yeah, they're doing this.
They've got someone they can contact that can assist them in trying to solve their problems.
Now, Tony, tonight we're talking about TAC cases, but before that, let's talk about what's in the news.
Yeah, look, there's been a lot of interesting ones. And if you recall last year, the government changed the law in relation to psychiatric injuries in car accidents.
That's right, Tony. About 12 months ago in October 2013, the TAC did change the legislation regarding psychological claims. They made it a lot harder for people to claim that they had sustained psychological injury as a result of transport accidents. For example, one of the amendments is now that people have to have ongoing treatment with a registered mental health provider for 3 years before they can even lodge their claim to show that they've got a serious injury.
That's a pretty severe impost. And Don, just on that, if you want to get a serious injury and get damages, there's these 3 little add-ons they've done.
That's right. That's what Anna just said. So it's really the add-ons are that you've got to have at least 3 years treatment, continuous treatment from a mental health practitioner, and the third one's got to have effects on a social relationship or and vocational
and work. Now, apparently, it's only a policy statement by the TAC. Even though it's law, they say that if you're not working, they won't force you to prove the third element. But really, you're at the mercy of the TAC, aren't you, Don? Anna?
Well, the literal meaning, Tony, is and it's got to affect your work. So I don't know how you get around with it. That's right. But let me read you. Here's a quote from the Assistant Treasurer, Gordon Rich Phillips, Tony. He was the one who obviously introduced this bill and eventually got passed. He says that the government was not seeking to restrict access to compensation, but to ensure that compensation claims for mental injury were made consistently.
So they've already, according to their figures, saved nearly $150 million.
So I don't see how this makes it consistently. This is just really restricted a person's right to claim, including these 3 very arbitrary sort of tests,
yes,
which, as far as I can see, and even the psychiatric doctors in the realms don't know how anyone can satisfy the test.
And to impose this other thing of seeing a psych for 3 years, isn't that just prolonging someone's agony?
Well, it is, and it's also difficult because I think a lot of treaters would say, well, if we're treating you for 3 years, is it working? A lot of psychiatrists, I imagine, would have difficulty in seeing a client for that long before they can be at the point where they can write a report to say, yes, these injuries are stable and still relating to the accident 3 years on.
All right, let's keep moving. There's been a significant increase in the number of psychiatric cases being lodged in the work cover area, Don.
Yeah.
What is it, 57 a week?
Well, that's right. It's gone up. It's actually more than it says. It's overtaken the number of claims lodged for mental disorders, wounds, lacerations and amputations.
Anna, sounds to me that in the workplace, as employers, we're obviously doing something wrong.
Well, yes, although it does say that 58 psych claims per week are now being accepted, which is showing, an improvement. But I think what people like Beyond Blue have come forward and said is that this is actually a good thing because maybe it's recognising that mental health is a really big problem in the workforce and that we have now reduced stigma to start reporting these types of injuries.
But Don, a lot of these are bullying-related claims, aren't they?
Yeah, that's right.
There's a lot of harassment, bullying
harassment,
and that sort of stuff. I mean, it's not a straight-out psychiatric injury because, oh, geez, I'm really working too hard and can't cope. This is the way they're being treated at work. So it's obviously a cultural problem in the workplace, you think, Anna?
I think there's certainly a big element of that, yes.
My concern, Don, is that just like there was no consultation with the TAC changes, what's to say that the government, if it gets re-elected, doesn't do the same thing and they think, oh, here we go, here's an opportunity to cut back on some claims and...
Well, Look, Tony, that's always a threat, isn't it? Because it's become the third leading workplace injury behind, believe it or not, musculoskeletal complaints and strains and sprains at work. So, yeah, it is a concern in the sense that it is increasing, and if they change the law, they'll do exactly the same what they did with the transport accident area.
I'll put my money on it that if they get re-elected, that's exactly what they're going to do.
Government's on notice, aren't they, Tony?
They'll cut back on psychiatric injuries in the workplace, and it just creates even more problems. And then obviously people look towards the federal legislation, won't they, Anna? General protections.
I mean, there's always an avenue to look at that. So, yeah, time will tell, I think.
Hey, you know the sad thing about this time? They even give themselves a dividend. They're complaining that their claims are going up in the value and they're paying dividends to themselves.
Yep, and I think the government has forecast that they're going to be drawing dividends for a couple more years, Tony.
Exactly. Anna, what's this about a traumatised security guard suing police?
This is a really interesting case, Tony. This is relating to the security guard who had to lead the police through the Monash Clayton campus after the shootings in 2002. As you recall, this was during a lecture. A lone gunman opened fire in a classroom and killed 2 students and injured a lecturer as well.
Severely maimed him, yes.
Yeah, and so the security guard was asked by police to lead him into classrooms looking for the gunman. This security guard was unarmed and not wearing a bulletproof vest. And in 2010, when he's returned to work at Monash Clayton campus again, he sustained a psychological injury by re-traumatising himself to that place.
Don, it's a very unusual thing to get a civilian effectively to get, front line, show me where the gunman is.
Yes.
And that's outrageous, don't you
I think it is. I think it is. And look, this just goes back to what we were talking about just before, Tony, about psychological injuries and all that. I mean, this guy was injured in 2002. Well, that's when it happened.
Yep.
It's until now he's realised, well, something's gone not right psychologically.
Yep.
Still suffering symptoms. This is, 12 years after the accident.
Well, he's obviously reflecting on what happened and what could have happened, and it's impacted on him in a big way, hasn't it?
Certainly. I mean, it's a life-threatening experience for him to go through. So I think it's not unheard of that this would come up.
No. Don, we've got to move quick because time's flying.
Yeah.
I want to raise this issue about Kate Shea. This is a lady that took the company to court, alleging sexual harassment.
Yes.
But there's been an interesting spin on the whole thing.
Well, she lost her case, and it looks like that during the proceedings that there was a few offer of compromises, Tony. So obviously the other side put an offer to this, say if you accept it...
An offer in writing.
Offer in writing.
Yeah.
And if you don't accept it, there's going to be consequences. In this case, it was cost consequences. So it's not only has she lost the case, but it looks like she's going to have a very substantial cost order against her for failing to effectively compromise her claim and take the offer.
And this raises a thing that I say to clients all the time. They get these offers in writing, they don't take them seriously. They keep saying to me that, oh, geez, I'm not getting enough compensation. The reality, viewer, is you're getting something for your trouble. If you really wanted proper compensation, the system can't afford it. So generally, if a lawyer's telling you to, or giving you advice about taking an offer, the reason for it is similar to what happened to Kate Shea.
Absolutely. There's significant risks to people when offers are made in writing for you. And this is a prime example of that. She was offered $440,000 at one point and then $200,000 at another point and then chose to reject both offers, and it's had dramatic consequences for her.
And now she's under with a massive legal bill.
Unfortunately, yes. It sounds like there's quite an ordeal against her now.
Viewers, we've got to go to a sponsors break, so stay tuned after the break. We'll bring you up to date with the Transport Accident Commission. Welcome back to the show. We're going to do a TAC update and go through a number of cases. Before that, I just want to raise this issue. Remember that horrific incident where that young man attacked the 2 police officers and stabbed them and then they shot him to death?
In Dandenong.
Yes. There was this incident recently where the police took a photo of another young Afghani man put it in the paper saying it was the fellow that they'd shot, and obviously he had very dire consequences for him, though.
Well, that's right. They've got this photo, which was not the assailant, if you
Yes.
like, Tony, and put it in the front page of the paper, all over the state, and it's caused rightly some
Massive grief
to
and,
the family and the kid involved.
Yeah, and the kid was sitting his exams too, so you can imagine the stress this has put him under, but also the stress upon his family as well.
I had a similar case of this many years ago where there was some rapist, and they got a photo of one of my clients, put it at the front page. He lost his job, he was ostracised by his friends, his family wanted to leave him, and it wasn't him. He had to try and convince people it wasn't him.
Yeah.
It was just a case of mistaken identity. Anyway, this is, I guess, a lesson to the papers and the media. Just be careful who you put in your news programs. All right, let's get on with this. The first case, Anna, it's a matter of Chuari and Transport Action Commission. 2014 decision of the Court of Appeal. What are the facts?
That's right, Tony. Tuari was a man who became a quadriplegic after an incident when he was 17, and he had fractures of the T3 vertebra, which meant that he had difficulty walking and also lost the use of one of his arms. Now, the TAC had supported him for some time, and he lived in a southern New South Wales town. Now, Mr. Tuari had the ability to drive if he was provided with a modified vehicle. So he's applied to the TAC to fund a Volkswagen Transporter vehicle, which had a special conversion, meaning that he could drive the car. Now, the TAC declined to fund this purchase, and they said to him that he had access to a high-ace vehicle that had already been modified, but someone else was required to drive that vehicle for him.
So, they're happy for them to get someone to drive it for him. Who's paying for the driver?
TAC would still fund that, however, that would be funding a carer to drive it, or his uncle who had purchased a high-ace vehicle could drive it for him as
Isn't that
well.
more expensive, though?
Yes, I think it is.
Think of it logically.
I didn't put
You've got a carer driving this car.
Well, unfortunately, it came down to a bit of a cost analysis at the initial finding, and that's what the Court of Appeal has really taken into account when reading it, is that maybe the cost analysis was too heavily weighted, and that the rehabilitation aspect of this should have been what was considered primarily.
All right, let me stop you there for a minute. Dom, in the first instance at VCAT, what happened?
First instance at VCAT, the tribunal member actually affirmed the TAC decision. And you should note, Tony, he was a T3 paraplegic, so he's paraplegic or down from the waist. So he's still functioning, loss of arm. But he had OTs who assessed him, occupational therapists, who all agreed to occupational therapists that he could self-drive and could manage driving and transport.
And he wasn't a danger to the community?
It wasn't a danger.
Okay.
It wasn't a danger at all. So it was to his benefit, and it gives him access to the community, access to get out there. He actually even gave evidence to say, well, look, I just want to get out, drive around a bit, surprise my family and all that about my driving and all these things, giving access to the community. And TAC said, well, look, we're not going to fund it. Their decision was based on the fact that they're saying you already had access to a vehicle, which wasn't his vehicle, which was bought by his uncle. His uncle was driving it.
All right, just on that. Is it the ideology of the TAC to rehabilitate, which is a point you made before?
Yes, that's true, but in this case, the TAC considered that the motor vehicle was not a rehabilitation expense or a rehabilitation service, but rather something that they thought was too costly. They did an analysis and said that in the previous financial year they'd funded about $1.7 million worth of vehicle modifications for, I believe it was around 140 people. And so they said that the cost of this vehicle, which was around $255,000, was exponentially high comparative to what they'd funded previously.
Well, Anna, my idea of rehabilitation is making a person feel independent. Making a person feel independent is rehabilitation, isn't it? No?
That's
I
right.
mean, isn't that the whole idea, to make the guy, him feel good about himself?
Well, that's right. And access to the community, trying to get back some normality to his life. Now, Tony, the thing is that the evidence that they introduced to TAC was all about quadriplegics, like how much we fund. The client, the applicant was not a quadriplegic, he was a paraplegic. So there's a lot of difference in there, and they relied on this evidence. And the tribunal member went on this sort of cost analysis on saying, well, it will be effectively cheaper to keep a carer there 24 hours or whatever, rather than funding this vehicle. But that's not in accordance with the law. The law says it's what's reasonable. And if it's a rehabilitation service, you consider on that basis.
And when you get to the stage where you've got people like Mr. Chuari, it's also about trying to rehabilitate him to become, make himself feel good about himself so he can become a useful member of society again.
Absolutely,
Is that correct?
Absolutely, Tony. And he did say that one of the aspects as to why he wanted this, so that he didn't always have, as he quoted, the entourage of carers with him.
Exactly.
It gave him the independence to do what he wanted because he had that independence to drive where he needed to be.
And the Court of Appeal, in their wisdom, saw fit to refer it back for a matter of result.
Yes, and Tony, what people don't realise is this legislation in Victoria, it's a beneficial legislation.
Exactly.
It's for the benefit of the injured or the victim. And these cases are victims of road trauma. So it should be read that way, and get into this analysis that it'll be cheaper to keep a care rather than a vehicle. It's not in accordance with what the Act's supposed to be about. So in this case, the Court of Appeal had no problems in sending it back. In fact, I think at the trial, the appeal, TAC conceded that, it probably wasn't a great decision to start with. So.
Well, the feelings of the injured party is pretty important too, I would have thought.
Absolutely.
All right, let's keep moving. Gilenza and Lucas is an interesting case. Do you want to give me the facts, Anna, before we go to the sponsors break?
Sure. Just quickly, Gilenza and Lucas and Gilenza and Ash were run together as two cases for one hearing. Now, this is to do with a woman who was involved in two transport accidents. The first one was in 2007, where she sustained injuries to her right arm, thigh, neck and shoulder and lower back. And then, unfortunately, she was involved in a second accident in 2010, when she sustained similar injuries, but more focused with the low back, the neck and the shoulder.
The issue in this case, viewers, is who's to pay the damages when there's some overlap and there's other injuries where there's no overlap. Now, it's the one insurer, so stay tuned. After the break, we will give you the verdict. Viewers, welcome back to the show. Just before the break, we were talking about this case where this lady had two separate accidents, injured different body parts, and the issue before the court was how do you determine her damages? That is, what proportion are allocated to the first accident, what proportion are allocated to the second accident? And Don, what did the court do?
Well, the court just split it in half.
Well,
the court said it's all real just theoretical stuff, because at the end of the day, it's the same insurer, compulsory third-party insurer. The money's come from one source. So really, he said, well, look, that's the assessment damages.
Well, there's nothing that flows from the fact that there's an award made against a party, because it's not as if there was two different insurers and could affect someone's premiums. I guess, Anna, if it affected someone's premiums, then you, as the subrogated party, wouldn't be happy to have it a 50-50 split, would you?
No, obviously the disentanglement issue between each accident would have been, I think, much more hotly contested had there been separate insurers. But I think here the judge felt that given it's the same insurer, there was really no point in trying to work out what stemmed from each accident.
And no cost implications that flow from it.
No, rather just award the lump sum and divide it as is done at 50% to each accident.
That's it.
Yeah, look, I think that's a common sense approach. And look, rightly so. I mean, just same insurer, money's come from the same party. But, I mean, in this case, the judge should have actually separated and listed it. And like Anna said, disentangled it. What rose from one injury, what damages rose from one accident, and what damages rose from the other one. But given that's the same insurer, it's the right approach.
All right, let's go on to the New South Wales decision of McLennan and nominal defendant. Anna, you want to give the facts?
Sure. Now, this is a complicated matter. This is a really interesting case. The facts are as follows. Mr. McLennan remembers that he left his car in a car park at a Sydney station at around 5 a.m. The next thing he remembers is taking his jacket and walking from the car. Then he wakes up after 9 a.m, the sun's up, he's looking around, there's obviously been a lapse in time and he's been badly injured. Now...
so he was unconscious?
He was unconscious for a long period of time, and then now it's left to the court to try and ascertain what exactly had happened, because Mr. McLennan recalls that there may have been a car that had hit him. However, the defendant in this matter, who was a nominal defendant, because we don't know who in fact the driver of the car was, if there was a car, was saying that his injuries were actually consistent with being assaulted.
Don, the interesting twist in this case is that the plaintiff had was to give evidence in a case,
Yes.
and he'd received threats from these people.
Yes.
And so the issue here was, did he get hit by a car, or did he get belted by someone, or did the people that threatened to beat him up were the ones that ran him over?
Exactly.
So that's the issue there.
That's right. And in this case, Tony, I mean, this is, like I said, a very complex case in the sense of that he drove home. He didn't report the accident straight away to the police. At the start, we're telling his doctors, wasn't really sure what happened. And then later on, gets his recollection. He even tries and go down to the train station to get witnesses by putting up posts up around, and no one came forward. So there's 4 hours that he's laying from the time he got out of his car to the time he wakes up. There's 4 hours in what appeared to be a busy car park at a train station. Yes. And no one saw him, no one saw anything. So it wasn't, in this case, it wasn't one where there's witnesses saying this happened, that happened. No one's come forward, so no one knows what happened.
Well, Anna, the sad thing about this case, from the plaintiff's perspective, the problem with him was that he had a history of lying. Well, he wasn't credible in the past, was he?
No, unfortunately.
What are some instances?
There had been history where, throughout the court cases at the early incidents, he had been found to be twisting stories to maximise his plight, and there'd been some issues with fraudulent use of funds in relation to some benefits as well. So I think credibility was an issue, and ultimately in this matter, for him to succeed, the plaintiff had to be believed, because he had to prove...
Well, there's no witnesses.
There's no witnesses, so he has to prove that it was a motor vehicle accident, that there was negligence in the driving of a motor vehicle, and that he had made all inquiries to try and find the driver.
Anna, if the driver has taken off, there's already a presumption that he's at fault.
Well, no.
Why not?
Well, that's what the judgment said. So there's 3 issues you had to prove. 1, you had to prove that there was an accident involving a motor vehicle. 2, that there was negligence on a part of the motor vehicle driver. And 3, that he made due search and inquiry, or due inquiry and search for the driver by notifying police and all those things. So, Tony, the first issue was there a vehicle involved? And the trial judge made a guess and said, look, out of the 2, I guess it was a motor vehicle. But the Court of Appeal said that's not the proper approach. The Court of Appeal should have said, on the balance of probabilities...
Can I stop you there for a minute?
Yeah.
In the first instance, the judge awarded him $645,000 worth of damages.
That's first instance.
Okay?
Yep.
So he put aside all this business about him having a propensity to lie in the past and all this business, and he found that he was credible enough to get him over the line. Then it gets appealed to the Court of Appeal, 3 judges. What was the result there, John?
The first time I sent it back, the second trial judge found that there wasn't a motor vehicle. Found that there was a transport accident or a motor vehicle accident, guessed it, and then said there was no negligence. And then a Court of Appeal who decided the matter said, well, there's not enough evidence to say it's not a guessing game. A judge is not supposed to guess. The judge should have said, on the balance of probabilities, there wasn't a motor vehicle accident involved.
Gee, I'll tell you what, this guy's got more lives than a cat, because when you think about it, right, he's gone back before another judge. Because the judge is guessing, he gets another crack at the Court of Appeal.
Yes.
And they fine for him again.
I know. That's why it's such an interesting case, because it has taken so many twists and turns along the way to get to this final decision.
But then, Tony, the issue about negligence. So
Yes.
the fact that the driver decamped was not enough to prove negligence, because there's too many factors involved that he didn't prove. That, for example, the driver's driving too fast, driving too close to parked cars.
But why
There's no evidence.
Why isn't weigh heavily against the unknown driver that he's taken off?
You still have to prove it. That's the whole point. You still have to prove that there was some negligence involved. It may well be that the plaintiff just stepped out and the driver never saw it, and it may have their own reasons. And the judges just said there's not enough evidence to prove negligence.
Well, I've been involved in a lot of cases over the years, Anna, where the driver's taken off, left the car there because they're either intoxicated, they've done something wrong, and they just don't want to be seen at the scene of the accident. They rock up later on, all cleaned up and whatever else, and maybe had time for the alcohol to subside, and they put their hand up and say, yeah, I got scared and I took off. But surely, I I would have thought that there's got to be a presumption favouring the poor injured person.
Well, not in this
Yeah.
case.
Okay.
Not in this case, Tony. But look, it may well, and he's actually, obviously his credibility came an issue as well. So I think that had a lot to play, and it just wasn't enough there.
Very complicated case, so what do you say to the viewers?
I mean, these cases, Tony, it's quite important that you start investigating cases straight away. And like in Victoria, if there is an unknown vehicle involved, you're required to notify the insurer or TAC as soon as possible. So you've got to start from the start, from day of accident.
Well, viewers, we've come to the end of the show. Thank you, Anna. Thank you, Don, as usual. Thanks for watching. Go to our social media. That is Facebook, Twitter, our website. Go to our past episodes. Stay tuned for future episodes. And always remember to stay safe.